Okay, this will be some literary practice at 140 words a minute. For the record, Mr. President, in the last several years, as inflation has impacted on everything from food to shelter, I have become increasingly aware that the American middle-class taxpayer, some 140 million strong, does not have effective access to legal help. I believe that the major reason why so many people fail to make use of an attorney is the cost of legal assistance. Many of those frightened off by the perceived high cost of legal help often will turn to other sources of aid to avoid the costs. Some resort to legal aid bureaus only to find that they do not qualify for assistance. Other sources are consumer complaint units of the state attorney's office or the attorney general's office. These usually have limited jurisdiction to resolve legal problems which are outside the scope of criminal prosecution. Sometimes they resort to self-help efforts, which often turn out to be more costly in the long run, as in the case of a contract or will, which is later litigated with disastrous results. From the observation of the great numbers of persons who seek legal advice and assistance for non-criminal problems, it can be seen that people want and need expert help in resolving legal difficulties. They are, however, often neither able nor willing to pay the high costs of retaining counsel. Clearly, there is a tremendous need for competent counsel that the middle class can afford. While we cannot reduce the legal fees directly, we can and should take steps to soften the impact on the average middle-class taxpayer. One approach is through group insurance programs similar to medical group insurance. In the case of United Transportation Union against State Bar Association of Michigan, the Supreme Court of the United States gave its approval to such plans, stating, "The common thread running through our decisions in NAACP versus Button, Trainman, and United Mine Workers is that collective activity to obtain meaningful access to the courts is a fundamental right within the protection of the First Amendment. However, the right would be a hollow promise if courts could deny associations of workers or others the means of enabling their members to meet the costs of legal representation. These decisions furnished the catalyst that spurred the development of the group legal services movement. As a result, several such plans have been established across the country. However, these plans are still in their infancy, and a major problem is underutilization of services by plan members. Mr. President, in my judgment, the legal profession and the Congress face the responsibility of finding a more workable means to make lawyers more affordable to the citizens of the United States. One solution that would begin to resolve this growing problem is the bill which I am offering today, a bill that would amend the Internal Revenue Code to provide a deduction for legal expenses. Businesses can already deduct most of their legal expenses. The poor are often provided free aid, and the wealthy can afford the help regardless of the cost. Thus, the tax deduction would be a great benefit to the average American taxpayer, who collectively, of course, foot the large part of the country's tax bill. This deduction is modeled after the medical expense deduction section of the tax code. There are two significant advantages this proposal has over any other plan. First, Mr. President, it makes lawyers more affordable to the average taxpayer, and second, it can be implemented immediately. The proposal will help the middle class because it will make legal services less costly to those who itemize deductions. For example, the deduction would provide sizable tax relief for those who experience catastrophic legal expenses, and the relief would be meaningful even for those whose expenses were not in the catastrophic range. Another advantage of this deduction is that a direct correlation would exist between the use of legal services of the taxpayer and the deduction to be taken. Put simply, the more the taxpayer uses an attorney, the greater would be his deduction. Unlike a group-type plan, the taxpayer only pays for what he receives. This deduction could be, if it were deemed necessary, tailored to provide greater benefits for the income group or groups that are most in need of aid. For example, the child care deduction sets a maximum income level above which a deduction is not allowed. This device could be used with my bill, and I would expect the committee to examine the possibility. Since the tax structure is generally progressive, the deduction limitation can be calculated to provide benefits to those who are not eligible for legal aid, yet who are not sufficiently well off to be able to retain counsel as a matter of course. Still, another advantage is the fact that the cost of adopting an amendment to the Internal Revenue Code would be minimal in comparison to the service programs. For example, this year alone, the Legal Services Corporation has granted $1.5 million for 19 small demonstration projects to test the effectiveness of various legal service type programs. Even assuming resulting economies of scale, once programs become operational, clearly the startup costs of these programs will be enormous. The proposed total budget for Legal Services Corporation for fiscal year 1981 exceeds $321 million. In contrast, the loss of revenue to the federal government in terms of taxpayers using this deduction would be de minimis. Another problem with the group type of prepaid legal insurance programs is that they will require the creation of a bureaucratic structure to implement them. Legislatures will have to enact statutes, regulatory agencies will have to be created or expanded, regulations will have to be promulgated, and most certainly numerous hearings will have to be held. All of these activities will generate the need for additional people to carry out these functions. Further, there may be numerous court challenges to any such programs. This will be some jury charge warm-up at 150 words a minute. For the record, Madam Foreman and ladies and gentlemen of the jury, it is now my duty to charge you in the law of this case. It is always gratifying when jurors show an intelligent interest in the evidence, because the law of Oklahoma makes you and you alone the sole judges of the facts, the truth, or want of truth of testimony. I am not allowed to intimate to you any opinion that I have along that line. That is your special province under the Constitution of our state. And if by chance you should gather any inference whatsoever from any remark or any ruling that I made as to the facts in the case, you would of course disregard such inference, because you and you alone are the sole judges of the facts and the credibility of the witnesses. Now, the state of Oklahoma charges this defendant with assault and battery with intent to kill. To that indictment, he has pleaded not guilty. And it is a cardinal and important rule of law of evidence that the defendant in a criminal trial, no matter what may be the enormity of the crime charged against that person, must always be presumed to be innocent of the crime for which he is indicted, until his guilt has been proved beyond a reasonable doubt. Now, this presumption of innocence does not cease when you retire, but it accompanies the accused from the time of his arrest throughout the trial and until the jury has reached a verdict of guilt based upon all the testimony to the exclusion of every reasonable doubt. It is the solemn duty of you, the jury, if not clearly convinced beyond a reasonable doubt to the contrary, to reconcile the facts proved with this presumption of innocence and acquit the accused. Our state's Supreme Court has said in one of its decisions that this presumption of innocence accompanies the defendant from the moment of his arrest and clothes him as with a garment until a verdict of guilt has stripped the presumptive robe of righteousness from this person. So at this time, he is entitled to recognition as a member of that class to which the presumption assigns him, the innocent and not the guilty. This legal presumption of innocence is to be regarded by you, the jury, in every case as a matter of evidence to the benefit to which the party on trial is entitled. Therefore, the accused in this case, presumed under the law to be innocent of the offense charged against him in this bill of indictment. And this presumption of innocence is not a legal or judicial fiction, but a vital and substantial legal right which justly entitles him to an acquittal at the hands of you, the jury, at every stage of the trial until the finding of the verdict, until it is proved by evidence in the case sufficient in force to convince each and all of you jurors of his guilt beyond a reasonable doubt. So I say this burden placed upon the state rests upon the state throughout the trial until the state has satisfied you by the evidence of the defendant's guilt. Now you have been selected as fair and impartial jurors, sworn to impartially try and determine the facts that are an issue and dispute in this case. Now, if you comply with your oaths to do so, then no one would have a right to criticize your verdict, and you would have fully discharged your duty as jurors. You should be careful, as I have told you on other occasions, not to allow yourselves to be influenced by opinions or expressions of opinions, if any, you have heard on the outside, for you are to decide this case according to the evidence that you have heard coming from the lips of various witnesses who have taken their oaths and testified during the trial.